you practiced law a long time before you got elected here, right?
Yes.
Okay, so
Well, I don't know what a long time is, a decade.
A decade?
Yeah.
Okay, well, I practiced about 25 years before I got here. So, civil side, right?
No,
You were a criminal lawyer?
I was.
No civil?
No, very little.
Well, I was civil, but I did get a guy jailed one time for having refused to answer depositions and interrogatories and document requests. 2 weeks he sat in jail because he, over and over again, refused to deal with any of the depositions, the document discoveries, or the interrogatories. So I know you only did criminal, but, what are the purposes of depositions and document requests and interrogatories?
Well, I would guess that if he went to jail for 2 weeks, a
No,
judge said him there, not a plaintiff.
My question to you were, what's the purpose of depositions, interrogatories, document requests?
They are to start recovery. I mean, I just use it as a discovery request.
Right, to discover information that may be relevant to a basic case. Now, in this instance, we have, in my opinion, a betrayal of the country by an attempt to overthrow an election. But that's what you know. We don't know much else other than a mob took over this campus, this Capitol campus, and broke into this building. And you got to begin somewhere. And you say, well, the questions keep adding questions. Well, maybe had they been the first people to respond to depositions, that would be one thing, but they've now had 800 witnesses to start developing the complexity and the breadth of what appears to be a really concerted effort to upset and throw away a lawful election. And you have two guys out of 800, and then you add Bannon and Mark Meadows, and that's it, four out of 800 who have refused depositions, interrogatories, document requests. And I appreciate you coming in here and trying to say, well, the record's unclear, but the purpose of discovery is very clear. And the purpose of this committee is very clear, to get to the bottom of this effort to overthrow the election and, in effect, overthrow this government. The number 2 and the number 3 people in line of succession as the executive, the vice president and the Speaker of the House, had their lives threatened. Says treason, the crime of betraying one's country, especially attempting to kill the sovereign or overthrow the government. And, criminal contempt, we're dealing with 18 U.S.C. 2381. Owing allegiance to the United States, levies war against them, or adheres to their enemies, giving them aid and comfort within the U.S. or elsewhere, is guilty of treason and shall suffer death, or shall not be imprisoned by less than 5 years. So, 800 witnesses. We now have 4 who've refused to provide any information. 1 is under criminal indictment for having refused to provide any information. We've got the Constitution of the United States has been victimized and assaulted. We have 5 deaths, dozens and dozens of injuries, countless people traumatized. And these 2 guys won't say boo. And it isn't a question of due process. They've had an opportunity to discuss this with their lawyers. They've had an opportunity to object and assert their rights, just as others have. So, I don't think there's any question as to the basics here about responding to reasonable discovery requests. And if they think that they are liable or culpable, then they can plead the Fifth Amendment. That's the rights that they have, that our Constitution gives them. But the Constitution also allows us to protect it. And so I appreciate you coming in here and reading us your brief. But I don't think there's any question on this one. You know, I don't have any idea what these guys did or didn't do. I know we've got 7.5 hours of phone calls that are missing that I'd certainly like to ask them questions about. I don't know if you want to respond to any of that, otherwise I'll yield.
Well, first, everybody has due process. Hard
course they
cases
do.
make bad law. And if the idea is getting to the truth and getting an enforcement of the subpoena, a criminal contempt motion isn't the way to do it. And that would just be my point.
Everybody's entitled to due process, and they've had it. So the question of due process is, this committee has given them so much time, has given them an opportunity to be heard, and they've refused to be heard, and they've refused to appear. It's the right to appear and the right to be heard, which they've refused to do. Now they're going to end up having a criminal referral, and they'll have an opportunity in the court, just like Mr. Bannon did. But now, all of a sudden, there is an indictment, and he's going to have his day in court. You know, in my entire life, I never thought we'd be talking about these kinds of things. This is so basic. The legal premises is so basic, the constitutional premises, the fact that we had a mob overthrow this place. In a million years, I would have never thought that would happen. And we got to stop this. We got to stop it now. I mean, I appreciate Ms. Cheney coming in and the way she's described the Constitution demands for us to protect it. And, you know, I want to do that. I want to believe that if it were a mob of liberals who came and overtook this campus and broke into this building, that I would want to get to the bottom of it. And I believe I would. And that's why I really appreciate the way Ms. Cheney and Mr. Thompson and the rest of the committee have taken this on. This is not fun stuff. This is unbelievable stuff. And it's something that our founders feared. And they allow us to protect the Constitution, and we must. And with that, I yield back.